Mississippi has one of the least regulated breaking lease frameworks in the country, consistent with the state's overall minimalist approach to landlord-tenant regulation. Mississippi is one of only a few states that has not adopted a comprehensive residential landlord and tenant act, and the landlord-tenant relationship is governed primarily by common law principles, limited statutory provisions, and the lease agreement. If you're a landlord or tenant in Mississippi, the lease is your most important document when a tenant needs to leave early. Let's start with the landlord's duty to mitigate damages. Mississippi recognizes the landlord's duty to mitigate through common law principles. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot simply leave the unit vacant and hold the departing tenant liable for the full remaining rent without making any effort to find a replacement. The landlord must take reasonable steps: advertising, showing, and accepting qualified applicants. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced. Because Mississippi's mitigation duty is common law rather than statutory, the standard of what constitutes reasonable efforts is less precisely defined than in states with detailed statutes. Courts evaluate reasonableness based on the circumstances, the local market, property condition, and landlord's typical practices. Early termination clauses are generally enforceable in Mississippi. The state does not cap early termination fees. Mississippi courts enforce contractual provisions between private parties, and a clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. Military members have the right to break a lease under the SCRA. Keesler Air Force Base in Biloxi, the Naval Construction Battalion Center in Gulfport, Columbus Air Force Base near Columbus, Naval Air Station Meridian, and Camp Shelby near Hattiesburg all generate military rental demand. SCRA terminations occur regularly across Mississippi's military communities. Mississippi does not have a specific state statute providing enhanced lease-breaking protections for domestic violence victims. Victims must rely on general contract principles or negotiate directly with the landlord. This is a gap in Mississippi's framework, and landlords can address it voluntarily by including a domestic violence early termination clause. Tenants may break a lease if the landlord fails to maintain habitable conditions. While Mississippi's habitability framework is less developed than most states, courts have recognized a basic implied warranty of habitability. If the landlord fails to address serious health and safety issues after proper notice, the tenant may claim constructive eviction. The tenant must demonstrate that conditions were serious, the landlord was notified, and the tenant vacated within a reasonable time. Mississippi's hurricane risk is a significant factor in the breaking lease context. The Gulf Coast, Gulfport, Biloxi, Ocean Springs, Pascagoula is vulnerable to devastating storms. When a hurricane damages a rental to the point of uninhabitability, the lease obligation may be suspended or terminated. Landlords should maintain adequate insurance and have a plan for communicating with tenants after a storm. From a practical standpoint, Mississippi has one of the most affordable rental markets in the country. Jackson, the state capital, has moderate demand. The Gulf Coast has military and tourism-driven demand. Hattiesburg has a university-influenced market. The Delta region has extremely soft markets where re-rental can take a very long time. Landlords in softer markets should set realistic expectations about vacancy periods. One best practice, because Mississippi's minimal statutory framework makes the lease your primary document, include a detailed early termination clause that covers the notice period, fee, security deposit handling, and property condition requirements. In a state where the law provides little guidance, your lease fills the gap. Another best practice, document your mitigation efforts whenever a tenant breaks a lease. Keep records of listing dates, advertising, showings, and when you accepted a replacement. This documentation is essential for establishing the departing tenant's liability. A third best practice, given Mississippi's significant African American population and HUD's disparate impact guidance, apply your damage claims consistently across all departing tenants. Pursuing aggressive claims against some tenants while writing off losses for others creates fair housing risk. Mississippi does not have a statutory cap on security deposits. The deposit must be returned within 45 days. These rules apply to broken leases and normal move-outs alike. For the complete guide to Mississippi breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.